Hello, Corey Brettschneider.
Hi, Glenn Loury.
Hey, how you doing?
Good. Pleasure to be back on your show.
Yeah.
Always nice to talk to you.
Here we are on the Glenn Show at bloggingheads.tv. I am Glenn Loury of Brown University and of Blogging Heads, and I'm talking with my colleague here at Brown, Corey Brettschneider, who is a political scientist, lawyer, political theorist, and ethicist. We're going to be an author recently of When the State Speaks, What Should It Say? A reflection about rights to free expression and how the state can manage problems of value offending speech in a manner that's consistent with the protection of free speech rights, but that also doesn't affirm the bad values. Did I get that right, Corey?
Yeah, I think that sounds like a good description in our discussion two times ago about that. I really enjoyed and thought got to some great issues.
Yeah, glad to have you here as a regular sort of on the Glenn Show, Corey. This is the third one we've done, I think. And want to hear what you have to say about the issue of the day. The issue of the day, one of the issues of the day being marriage equality of the rights of gay persons to equal treatment in the law with respect to marriage. And this is an area where you will be an expert and I will be a not uninterested and perhaps not uninformed commentator. But I want to let you get started by framing the issue, and then we can have our conversation.
Sure. So generally, I mean, one reason to talk about this important issue, an issue that I think wasn't on the table constitutionally speaking 10, 15 years ago, although in political theory it's been an issue for some time. Thinkers like Stephen Macedo, for instance, have been advocating for a right to gay marriage, and his opponent at Princeton, Robbie George, opposing it for over 10 years. But now this isn't just some theoretical issue. The Supreme Court has recently heard oral argument in two cases, one about Proposition 8 in California, a proposition that revoked the right to gay marriage, and then also a separate case about the constitutionality of the Defense of Marriage Act, a federal act banning federal recognition, anyway, of gay marriage as concerned things like federal benefits that are conferred.
Okay, so summarizing these two big cases at the Supreme Court, which were argued and about which decisions will be handed down at the end of this term, one challenging the proposition in California that banned gay marriage out there by ballot initiative,
right,
and the other raising questions about the Defense of Marriage Act, the federal statute that, in effect, prevents the federal government from recognizing gay marriage. Again, I wonder if I've described that correctly.
Yeah, I think that's it. I mean, my understanding of DOMA is, I mean, I think, there's a question about why it exists, and I think it's clear that it was an attempt to bring in the issue of gay marriage during the Clinton administration as a possible wedge issue, and Clinton signed the bill rather than opposing it. But technically what it does is it tries to deny any federal recognition to gay marriage, and it results, I guess, in a system in which even if marriage is recognized by a state, that at the federal level there is no recognition. So if it came to questions, for instance, of, as I understand it, certain federal benefits, like perhaps Social Security, the federal government wouldn't recognize. It might recognize certain rights of same-sex couples, but it wouldn't use the term marriage and wouldn't recognize it as marriage.
Okay.
So there's a federalism issue there, and then in both those cases, I think, though, there's the deeper issue of whether there is a constitutional right to gay marriage under the Equal Protection Clause of the Constitution that's akin to not to equate the two cases, but there's an analogy that the litigants are trying to draw between the guarantee in Loving versus Virginia of interracial marriage and the guarantee here of a right to gay marriage.
Okay, hold on a minute, because
Sure. Sorry.
just try to get the lay of the land here, because we got these two cases,
Right.
Different kinds of arguments, one about federalism, another about equal protection.
That's right.
We've got some of the commentary that I've heard is predicting or imagining that the court could find its way to kind of a middle ground here by striking the Defense of Marriage Act on some basis, and I'm not sure exactly what the basis would be, but I guess it's a federalism argument of some kind, and then not, foregoing the opportunity to strike down the California ballot initiative, where an equal protection claim would need to be affirmed in order for them to do so. Is that your thinking as well?
Well, there are all sorts of options on the table. The most radical and history-making option would be a clean one, that the court could say there is a constitutional equal protection right to gay marriage. And that, I think, would result in both striking down DOMA and the Prop 8 initiative in California. But as you say, there are lots of other options on the table. In the DOMA case, the court could say that there is no federal power, for instance, to define marriage. That's one argument that Justice Kennedy, in the oral arguments that I listened to not long after they happened, seemed like he might be sympathetic to, because it merges his federalism limits on federal power concerns with what's been a somewhat sympathetic view of the rights of gays in the society. Another question, though, in both cases that took up a lot of time were standing issues, which raise, I think, interesting issues in democratic theory. In the Prop 8 case, there was a question about who the defenders of Prop 8, who had standing in the Supreme Court were, given that the state officials in the state don't want to defend the proposition. So it's basically fallen to those who have proposed the initiative to defend it. And at the federal level, there's no ballot initiative, there's no plebiscite. So there's a separation of power. This just wouldn't arise if the question was a federal statute. But because California has these ballot initiatives, there's this interesting question of democracy, of who can defend the initiative, given that even if no federal official wants to defend it, given that it comes in some sense from at least the claim is from the people. But they could deny standing in that case, in which case there wouldn't be a decision on the merits.
Okay. Now, so what you've just been talking about, these issues of standing and such, are almost down in the weeds, legal type stuff. What about the political theory and kind of ethics aspects of this problem or this question?
I think the most interesting substantive questions, assuming we get past the legalistic issues, although there are interesting, I think, political theory questions about democracy there, are about the straight argument of whether or not, if we apply equal protection analysis, the challenge, there are two issues, I think, that the court will, if it gets to this point, will have to ask. The first is, what's the right level of scrutiny that gay couples, gay individuals get under equal protection analysis?
The right level of scrutiny.
Right. So basically the court balances between the interest of the individual, the rights holder, and the interest of the state in passing a particular law in different ways, traditionally, depending on the kind of group that is appearing before the court. So because the 14th Amendment was so obviously a corrective to slavery and racial discrimination, African Americans have traditionally received the highest level of scrutiny, at least as the court sees it, under the Equal Protection Clause.
Highest level of scrutiny. Can you just explain what you mean by level of scrutiny?
The burden, you could think of it as a sort of seesaw, where the advantage is to the, in these sorts of cases, is placed heavily in favor of the litigant in the case of strict scrutiny. And there's a very heavy burden on the government to show that it can override what are basically the presumptive rights of the litigant. So it needs to show both a compelling interest, that's an interest in the goal of the law that in the court's terms is compelling, and that basically means a really good reason. And it also has to show that when it comes to its way of achieving the goal, what the court would sometimes call the means and fit, is narrowly tailored, right?
Now, I understand this language in reference to affirmative action.
Right, exactly. It's
where
the same.
Racial preferences are going to be subjected to strict scrutiny by the court in order to pass muster. There has to be a compelling government interest in the adoption of the preference favoring, let's say, African Americans. and the preference adopted has to be narrowly tailored. That is, there cannot exist some alternative way of achieving the same objective that does less discriminatory harm, in this case, to the rights of whites and non-blacks if the program favors blacks. What does it mean in the context of gay marriage, say?
Well, the court has never applied a strict scrutiny test, the Supreme Court of the United States, in regard to gays. So one question is, what's going to be the kind of test that they use? And the assumption of many people has been or some people has been, that it will use a very different kind of test, that it will use a test that is, at least in striking that balance, much less protective. And the test is called rational review. And on rational review, all the government needs to do is to show not a compelling interest narrowly tailored, but basically to show that it has some reason for the law.
Hold on just a minute. You're discussing now how the government might defend the Defense of Marriage Act?
Before we even get to that issue, I guess I'm saying that in both cases there's a question of whether there's an analogy with the case of race, whether gay couples are going to get strict scrutiny or whether they'll get this much lower level of protection called rational review. And if, as it looks in the past like it's rational review, the government's burden is just much easier to meet than it is in these cases.
Burden on behalf of what?
That its obligation to the kind of reason that it needs to show.
Meaning that it would be easier for it to justify discrimination against gays if the court were to apply rational review and not strict scrutiny as the standard.
The test is much, at least on it, it looks like it's a much easier thing to do.
Okay,
but now here's the twist: is that the litigants on behalf of the gay couples think the government has no good reason at all, not even a rational reason to justify.
Can we come back to that?
Sure.
So this is a question of whether there's any rational argument on behalf of not treating homosexual marriage in the same manner as heterosexual marriage.
Correct.
But before that, I want to discuss the issue of the level of scrutiny being comparable to that's implied by the Loving versus Virginia ruling, which outlawed states' prohibition of interracial marriage.
That's right. Yeah.
And the question I want to ask about it is, are we talking about an analogy here, or is there something more in the legal logic that would lead to the application of the same levels of scrutiny? In other words, does one have to demonstrate a sociological premise, which is that race and, in quotes, and sexual orientation are comparable categories in some sense of the nature of the oppression, the extent of the animus that motivates it, the damage that's done to the people who are subjected to it? Or are we simply playing with words? That is, and I don't mean to seem disparaging in saying so, but are we simply trying to fit stuff, well, this was like that. They had this for the blacks, why shouldn't you have that for the gays, without bearing any responsibility to demonstrate that, in fact, the disability associated with being gay really is comparable to, analogies, and I perhaps betray a little bit of skepticism here in my own view, and I don't mind doing so, are dangerous things. They shape narrative. They can diminish the authority of narrative, by assimilating the claims of African Americans to equal treatment under the law to the claims of gay prospective marriage partners, to the claims of, by assimilating them, by embracing that analogy in the form of the sort of highest judicial ruling of the court. Is there not some cost that's paid by those who have an investment in the narrative weight of African American moral claims through such an assimilation? Isn't that something to be worried about? Okay, so I've stated my question.
Yeah, no, and I think the history of the court's jurisprudence on this issue, anyway, has been to say that there is a difference, and it's a controversial claim for sure, in this sense that there's a historical difference, for one thing, that the Equal Protection Clause, the originalists on the court who tend to defer to the meaning of the terms at the time they were passed often say, look, this is a clause Equal Protection Clause is about race. That's what those who passed it and enacted it had in mind, and those who lived at the time had it in mind. And so that's one reason to think that there's a difference. I think the other assumption, which is much more controversial, is that there's an ascribed status that comes with race and ethnicity. I think it's not just race now that gets that level. Certainly, it's national origin or ethnicity.
Mm-hmm.
But the assumption is that the difference, the disanalogy with gay couples is that that this is an ascribed status that has a kind of history to it that's not chosen. I don't think the assumption is that it's genetic, which I think would be wrong, but that there's no choice involved. And I think the assumption of the rational review analysis is the very controversial, I think, assumption sometimes that this is different from race because it is, in a sense, a choice. And that's an assumption that in order to win the case, they could win the case even with this very low level of scrutiny, and even if the court sticks to rational review.
I'm sorry, who could win the case?
The litigants on behalf of the gay couples could still win, even if they don't show the analogy with race. But there is one very serious issue, which is, a lot of people think that being gay is not something that's chosen, and there's evidence to show that it is a status that one is born with rather than one that one chooses. That would be the argument.
Neither of us are
the level of scrutiny.
Neither of us are genetic or behavioralist, social scientists or scientists. So
Right.
I think everything
That's
here
true.
has to be viewed with a certain degree of qualification. But I want to say
certainly
this.
want to flag it. Yeah.
I don't even know if it's a well-formed question. Whether or not a certain pattern of behavior or complex of behaviors, quote, is a choice, close quote.
Mm-hmm.
Or at least I feel the need for excavation and, sort of making clear exactly what the premises are by which I'm going to classify behaviors as those subject to choice or not. I can see where this kind of thing would come up in criminal law with respect to a defendant's responsibility for certain acts and, an insanity defense and things of that kind. Was a person acting under some kind of compulsion that they couldn't have been expected to, be able to regulate their behavior or something. But I'm not sure I know what it means to ask the question and answer the question. I don't know exactly what the character of the evidence would be that would answer the question for me. And I must tell you that on its face, it seems implausible to assert about such behavior that there's no element of choice in it. There must be, in a population, a range of people for whom there is, as it were, more or less choice about behaviors of this kind. There are... Anyway, I speculate beyond my knowledge, and I just put this on the table because I really want to know what you mean, or what anyone means when they say people have or don't have a choice about this behavior.
Yeah, I guess a better way, in my view, of putting the challenge to the court's different levels of scrutiny in regard to this issue is to say, maybe not to talk about the choice issue, or whether there is a choice or not, but to talk about status, and to say, look, being gay is not just a behavior or a discrete behavior, or even a series of behaviors. It really constitutes a core part of one's identity in the same way that gender or religious belief sometimes or ethnicity might be. The argument, I think the best argument, and this is my view, I'm sympathetic to it, for upping the level of scrutiny, certainly higher than rational review. Maybe gender gets a sort of intermediate level of scrutiny, but maybe even to strict scrutiny is to say, apart from the genetic issues, which, as you say, neither of us are geneticists, that being gay isn't just a series of behaviors. It isn't one or multiple acts. It's who one is in a fundamental sense. And if there's discrimination against that, then that's the sort of thing that the government should be the court and the Constitution is very leery about it allowing. And I think that
okay, so
point,
again,
that status is going to, even if...
I'm sorry, Corey. I'm sorry to interrupt, Corey, but
please,
I want to
please.
slow you down because not everybody is an expert.
Sure, sure.
So one kind of question here is about rational, rational review of the government action, and can reasons be given that justify it. And
Right.
another path here, another strand of argument here has to do with level of scrutiny,
Right.
and whether or not the highest level of scrutiny is warranted. And the remarks you were just making about thinking about this as status and about a person's gayness as an elemental aspect of their identity, and therefore discriminating on the basis of that is, rather than making claims about what they can or cannot choose, simply making claims about who they understand themselves to be and whether or not they're due the respect and treatment on that basis. And that's a path potentially to justifying the strict level of scrutiny for government actions that discriminate against people who are gay.
Yes, that's one possibility that I was suggesting. Exactly.
Okay, thanks for allowing me to do the summary. You were going on to say something else.
Well, I was going to say, so there are two issues that we're really talking about. One is what should there be an analogy in the level of scrutiny between race and being gay? And I was trying to give arguments that you just nicely, succinctly repeated that suggested that, I think, I'm just putting my cards on the table, the court should up the level of scrutiny to be at the same level or close to the level that it uses when it comes to race. Yeah. But there's a second point, which I think you were also getting to, which is even if the court doesn't do that, even if it uses rational review analysis, there really was a burden on the government to just, so not on the government in this case, because the Prop 8 anyway is being defended by the defenders of the proposition, the proponents of the proposition. But there's a burden on anyone who wants to defend Prop 8, or DOMA for that matter, to show that even on the lowest level of scrutiny that there's basically some good public reason for the law, some good reason. And that might seem like an easy thing to accomplish, but as I listened to the arguments, I was really struck by the fact that I'll say I just don't think there's a good reason. This
is now the argument. Excuse me again, Corey. This is now the argument about how does the gay person getting married hurt anybody else?
Well, or just it's a challenge to those who want to deny equal protection of the law, want to deny a constitutional right to gay marriage, to show some reason that's not theological for why we should not extend the right to gay couples. What's the reason for the denial of the right? That's the question, and it was a real struggle to find any. I mean, there was some speculation, but
when I've heard people in the Sunday shows and such discussing this weeks back when it was in the news, the Ralph Reeds of the world were saying, well, traditional marriage is the context within which children are best raised, and that there's tons of evidence. And I don't have my hands on that evidence. It's not my area of expertise. To the effect that, one man, one woman married in the household raising the children is the best arrangement for children, and that, therefore, the rational justification for limiting the state's sanction of marriage to a man and a woman is that the family is this social unit that has these beneficial effects.
Right.
And that will be disputed, I assume.
Well, I mean, I've never seen any evidence to that effect. That's the problem with that sort of argument. It's like, it could be an argument. I think that's a potential argument that shows some kind of harm that comes from gay marriage as opposed to heterosexual marriage. But when it came to the briefs and to actually asking for the evidence, I don't think there's anything that's been produced that shows that. The best argument that they could come up with is that the institution of gay marriage is too new to know that this was the sort of thing that some of the conservatives on the court flagged, that this kind of research might appear at some point. But that doesn't sound, like a good argument to me. Right.
Well, now what about...
So there is no evidence, I think.
Help me understand then why this assertion would not have any carry any weight. The assertion being, there are millions of people whose sensibilities will be offended, whose understanding of the institution of marriage is based upon whether it be religious or other sources that favor a man and a woman and that are disfavor same sex. and that those people, their sense of the right ordering of our public affairs, their whatever, they're going to be hurt by this. They're going to be undermined in some way by. They're going to, disfavor it, and that's a rational reason that needs to be taken into account. And I have disallowed that they would have religious basis for this, but I can imagine extending this kind of argument to say, so what if it's based on religion? I mean, they believe the religion. They believe it fervently. It's their way of making sense in the world, and you've just put, a fly in the ointment for them.
Right. So this brings us to an earlier case where the court considered that sort of argument, Lawrence versus Texas, which was about the question of whether or not you could criminalize sodomy for gay couples.
I remember that case.
And there was an argument and Justice Scalia has often shown appreciation, I would say, for the sort of argument that you're making, which is that, look, the tradition of the religious arguments, the felt preferences of opponents of gay marriage could constitute a rational basis. And what the court said in Lawrence, and again, I completely agree with this, is that might be a reason in some sense, but it's not the kind of reason that meets the burden of a rational basis. And I think the court has some idea of public reason in mind here, that at least at minimum this has to be a reason that goes beyond feelings or emotion or certainly disgust, and that has weight, for all people in the polity, regardless of whether they hold a particular religious belief or not. And the court actually used kind of strong terms to describe that sort of solely emotional based reason. It used the term animus, which implies hatred. But I think that it's actually the court's gesturing when it talks about animus-based reasoning in a broader way. It's reasoning that once we find that it's just based in emotion, the emotions are caught up, I guess, with the lack of recognition of the equal status of, in this case, of gay couples. So, I think you want to disagree and we should talk about it, but that kind of reasoning of just looking to either the felt preferences or the religious tradition doesn't, I think, have constitutional weight. It's why the court was asking about these sort of more evidence-based approaches. And I think there's good reason for that because, felt preferences lead us in all sorts of bad directions.
the Jim Crow Southerners had preferences, and they took a hit when their preferences were overridden by the affirmation of the rights of blacks to equal protection. It's true.
That's right. And racism, had reasons behind it, right? I mean, it's not like Calhoun or the defenders of slavery, or after that, the defenders of the system of segregation didn't provide reasons of some kind, and certainly they had very strong felt preferences. But I think the legacy of or where we are in history now is we look at those and we say those are reasons of it. They certainly weren't a compelling interest or anything. But I don't even think we think they were. But there was a rational basis for those.
No, I agree. I think we think now, today in the 21st century, that the 19th century quasi or pseudo scientific justification for slavery and racial domination were wrong, that the Africans were incapable of, the mental requirements of modern civilization, that they were, sort of naturally predisposed to servile and menial and manual labor and all this kind of thing. The superiority of the European being reflected in everything from Jefferson's reference to the physiognomy and, the kind of how people looked and whatnot to the moral basis of it, when, they're heathens, we're Christians or whatever.
Right.
I think we all recognize that those were bogus reasons.
Right.
But
that's the claim here, that these reasons on behalf of denying extending the right are analogous.
But I wanted to take it further because I think I have revealed I'm a little bit skeptical about the analogy with race. I mean, maybe I could be, expected to be a little bit skeptical. But but what I want to say is, the institution of chattel slavery was more than just a mental image in the mind of some philosopher or sociologist trying to justify racial domination.
That's right.
It was, in fact, played out over centuries. Physical violence, the forced appropriation of labor, the separation and subjugation of millions of people for generations in a systematic way, the coercion, the etc. So the aversion that one has that then may get reflected in these fine legal points and in these constitutional principles actually has a historical root that is based in materialism, in concrete, real actions.
That's right.
And it again, I think, let me make my own analogy. Okay. This is an analogy about analogies.
Right.
Okay? People who descend from victims of the Holocaust don't take kindly to the easy appropriation of their experience to, in an analogistic fashion, make some argument about something else.
Yeah.
Okay?
Yeah.
Because they feel like it diminishes the lived experience and real force of the specific historical events that were being perpetrated in the murder of the Jews in Europe.
Yeah.
Likewise, a person might say that, again, whatever the logical equivalences that you might be inclined to draw or the rhetorical strategies that you might be inclined to adopt, the actual lived historical experience of institutionalized racial domination and chattel slavery involving the forced extraction of labor from scores of millions of people across continents over centuries mustn't be telescoped down and reduced to something else, which is not it.
So I have a response to that, which is, first of all, to acknowledge as you say, the distinctness of chattel slavery in the African American experience in the United States, and I think that I agree with you too about there are certainly many distinct and terrible things. That's not strong enough a word about either of these cases. Horrific things,
sure.
The Holocaust. But I think that there's a difference between people who want to equate two different things, to just return to the issue of how we reason, and the question of analogy. So even though I agree about the mistake of equating different kinds of experiences, I do think that analogy is often useful and fundamentally important to the rule of law and to systems of international law and domestic. So in the Holocaust case, what I would say is, despite the unique attributes of the show of the Holocaust, that there was a crime that was committed there too, which is universalizable, and the crime was genocide.
Yeah.
And what comes out of the Holocaust, without, I think, in any way diminishing what happened, is the recognition of a universal human right against genocide and a crime against humanity that occurs when it's committed. Yeah. And the only crime of genocide is not the Holocaust, there are others. So I think we need to do both. You need to recognize the distinct harms that happen in when particular crimes happen, like the Holocaust or like slavery. And then we also have to draw various universalizable lessons from it, including, in that case, the crime of genocide. But in the gay rights African American analogy, I think the thing that we draw is the notion that a reason for a law, especially one that discriminates, has to have a basis outside of emotion and outside of that's explainable across different populations, and that's not just based in